अज्ञानतिमिरान्धस्य ज्ञानाञ्जनशलाकया चक्षुरुन्मीलितं येन तस्मै श्रीगुरवे नमः.
Namaskar, this is Tulja Bhavani. I welcome you all to my online class on business law. So, dear viewers, my main intention of teaching is spreading of knowledge, and I follow the principle of starting from the roots and reaching till the fruits. It means that we'll be learning the subject from the basics so that even a layman can understand the subject of law. Before we enter in our today's class, let us have a recap of what we have learned in our previous class 001. So yesterday we have learned about law. We have started from the nature, then why the nature looks to be so beautiful. Because nature follows certain rules, certain laws, then we have learned the meaning of law in general. Then when the law was born, why should an individual know about law? Then the legal history of law in India, which was categorized into 4 types. First one was the ancient India period. Second one was the Muslim period. Third one was the British period, and the fourth one was India today. In our today's class, we are going to enter into the subject mercantile law, and from today, our main concept starts. So let us have a look on the PPTs, which I have prepared for the sake of the students for their better understanding. Right. We are here with the PPTs. Fine. This is the introduction PPT. We'll start from the beginning. Fine. Right. Mercantile law. Mercantile law, known as commercial law or business law or trade law. I'll explain each and every word which comes in my PPT when the time comes. That is, when the next slide comes, I'll be definitely explaining. So mercantile law is popularly known as commercial law, business law, or trade law. Generally, the students get confused that mercantile law is different, business law is different, commercial law is different, trade law is different. All these laws are the names of mercantile law. So, mercantile law is known as business law, and it is a branch of civil law. It deals with business and conduct of people who are associated with such business. The very first word of our subject, business law. Yesterday I explained you about the meaning of law. Now I will explain you about the meaning of business. Business means buying and selling of goods and services with the intention of making profit. The main intention is profit maximization, earning of profit. If you are buying and selling the goods not with the intention of making profit, it means you are not doing any business. You are doing a social service, or you are doing a service where there is no profit, no loss. So business law deals with business and conduct of people, how the business is going to be carried out, and who are the people who are associated with these business, and what is their conduct, how they are being regulated, how they are being controlled. So this law speaks about the business and the conduct of the people who are associated with the business. Dear viewers, if you see the world of commerce, commerce means aids to trade. Again, the word trade means what? The transfer of goods from the producer to the ultimate consumer. Trade means the transfer of goods from the place of production to the place of consumption. Here, what we are doing, we are taking the goods from the manufacturer, from the producer, and giving in the hands of the consumers. Generally, the students get confused that consumers and customers are one and the same. Consumers and customers are not one and the same. There is difference between these two words. Consumer is a person who purchases the goods for his self consumption, and customer is a person who purchases the goods for his consumption or for the consumption of others. So the world of commerce is governed by business law. Commerce means aids to trade. I told you the meaning of trade. Now aids to trade. Aids to trade means anything which helps us in transferring these goods from the place of production till the place of consumption. Whatever help we have taken from point 1 till the destination point, everything comes under commerce. So the world of commerce is governed by business law. Then business law includes what? What does business law includes? It includes the Indian Contract Act 1872, the Negotiable Instrument Act 1881, the Sale of Goods Act 1930, the Indian Partnership Act 1932, the Insurance Act 1938, the Consumer Protection Act 1986. This Consumer Protection Act has been modified in 2019. Now there is a new Consumer Protection Act 2019. The Securities Exchange Board of India Act 1992, the Information Technology Act 2000, the Limited Liability of Partnership Act 2008. So all these acts will cover in our future days. I'll be explaining, don't worry, I'll be explaining each and every act when the time comes. Dear viewers, here is a definition of mercantile law. It is written as mercantile law means that branch of law which is applicable to or concerned with trade and commerce in connection with various mercantile or business transaction. In simple terms, this definition is focusing on how the business is being governed. It tells that it is concerned, mercantile law is concerned with trade. I explained you what is the meaning of trade. It is concerned with commerce. I explained you that commerce means aids to trade. And with various mercantiles. Mercantiles means what? The business peoples or business transaction. Business transaction is otherwise called as the financial transaction. Now the question arises, what is a financial transaction? Financial transaction means the exchange of money or money's worth from one person to another person is called as a business transaction or financial transaction. In case of business transaction, there must be minimum two parties. One party should receive the benefit and the other party should give the benefit. This was in brief about the definition of mercantile law, which was given by S.R. Davar. Right. Main sources of Indian mercantile law. Dear viewers, you can see on the left hand side the England flag. So why I have inserted this flag means the Indian mercantile law has huge effect of the English mercantile law. Why it has means in 1600 Britishers came to India and they ruled India till 1947. 1947 means more than 346 years they have ruled us. More than 347 years they have ruled us and they have given us the freedom on 15th August 1947. So when they have ruled us for such a huge period of time, obviously their impact will fall on us. Now, in our class, you can even observe that I'm speaking in English, and this English language has its roots from England. It is not our country language, it is not the language of India, it is not a national language, but still I'm making use of this language because majority of the Indians understand English language. Right. So, main sources of Indian mercantile law. It is copied from the English mercantile law. As I said, they have ruled us for a long period of time. So, the Indian mercantile law has been copied from the English mercantile law. Majority of the laws were enacted during the British period. Whatever acts you have seen, those acts were enacted during the British period. They have come during the period of the Britishers, because the main intention of Britishers in coming to India was to do the business. But when they have come to India, they found that there was no unity among the Indians, and this loophole, they started taking it as an advantage and they started exploiting the Indians. India looked to them as very beautiful because it was very wealthy and it was a peaceful place to carry the trade and commerce, and they called India as a golden bird. So Hindus and Muslims were governed by their own religious laws. Yesterday we have discussed that about the legal history of India. We discussed that in India, Hindus were ruled by the Hindu law, Muslims were ruled by the Mohammedan laws, and those who were not under the categories of Hindu law or Muslim law were governed by the English law. Then comes the sources of mercantile law. What are the sources of mercantile law? There are four sources of mercantile law. The first one is the English mercantile law. English mercantile law, as I said, see, its classification is given on the right hand side. English mercantile law. Right, English mercantile law. English mercantile law, English Britishers have come to India, as I said, in the year 1600 in order to do the trade and commerce. So they had their impact on the mercantile law, and the classification of English mercantile law, the sources from where this English mercantile law has come is given. First one is the common law. Common law, it means this law is applicable to all the people who are staying in the country. It is common for everyone. This common law is the judge-made law. It is based on the customs and traditions which are prevailing in the society and followed from generations together. So this common law is based on the customs and traditions. I said that Hindus have their own Hindu law, Muslims have their own Muslim law, that is Mohammedan law. So this law is the oldest law and it is unwritten. It is evaluated through the scholarly work, and as I said, it is a common law. When it is a common law, this law is applicable to all the people who are living in the society. Then comes the equity law. Equity, the word itself says that this law is based on the fairness. Justice were delivered by the judges based upon the previous judgment given. So this law has become a supplement to the common law. This law has come into existence in order to remove the deficiencies which were existing in the common law. So this law, as I said, it is based on the principle of fairness. Then what happened is the Judicature Act, which was passed in the year 1873 and 1875, removed the distinction between the common law and equity law. Now both these laws are one and the same. Then come the statute law. Statute law means the law which is being passed in the parliament. It is a parliamentary law. Yesterday we have learned about parliament. In a simple language, I told you what parliament is. Parliament in simple terms consist of the Lok Sabha, Rajya Sabha and the President of India. One of the superior, so it is one of the superior and most powerful source of law, because law is being framed in the parliament. When the law is being framed in the parliament and when the law get the assent of the President of India, no one can question such law. So this statute law overrides the common law and the equity law, because it is the supreme law, and whatever law is being given, whatever act is being passed by this parliament, that has to be implemented by all the courts in India. Right, then comes the case laws. Case laws are those laws which are based on the previous judgment given by the judges. So previous cases were referred by the judges before making any judgment. So the case laws have acted like a guide to the judges. Then comes the lex scheme. Then comes the lex or mercatoria or law merchant. Mercatoria or law merchant. Right. What it says is it consists of legal principles that are based on the customs and usages. As I said, that it is based on the customs and usages. Customs means what? These are the traditions which are prevailing from generations together. Right. So, as I said, that Hindus were governed by the Hindu law, Muslims were governed by the Muslim law. Those who were not governed by either of these laws are governed by the English law. Then comes the statute law. What I explained was here, right? Statute law, as I said, that a bill will be passed in Lok Sabha. After getting the approval in Lok Sabha, it will be sent to the Rajya Sabha, and if Rajya Sabha approves it, it will go to the President of India for their final approval. And like this, certain laws are being formed. So sometimes what happens is a bill will get the maximum majority in Lok Sabha and it will not get the approval of Rajya Sabha, but it will get the approval of the President of India. Once if a bill gets the approval of President of India, it becomes an act and no one can question such act. For example, I can give you the example of a triple talaq bill which was passed in Lok Sabha and got the approval of the President of India. There was lot of opposition from the minority community in India. So dear viewers, right. So these statutes law which gets the approval of the President of India cannot be questioned by anyone. But these statutes laws are governed by the customs and traditions which are prevailing in the country. Hindus are governed by Hindu law, Muslims are governed by their Mohammedan law. I can give you one more example. As per Hindu law, only monogamy is allowed. Monogamy means having only one living spouse. A person is not allowed to go for the second marriage when his first spouse is alive. If he is interested to go to second marriage, he has to divorce his first wife, or the absence of first wife is required, that the wife should be dead. So if the wife is not alive and if the divorce is over, then the husband or wife can go for the second marriage. So as per Hindu law, monogamy is allowed. But as per Mohammedan law, polygamy is allowed. Polygamy means having more than one wife. So Muslims can go for 4 marriages and they are legal as per the Islamic law. Now, I told about monogamy and polygamy. This is as per Hindu law, and as per Muslim law, there is one word called polyandry. Polyandry means a lady having more than one spouse, and this polyandry is opposed, is illegal both in Hindu law as well as in Muslim law. Right. Now the judicial law and judicial law and the customs and usages law. Judicial law, as I said earlier, judicial laws are similar to the case laws. These are based on the previous judgment given by the judges, and they are referred before passing any judgment. They act as a guide to the judges. Then customs and traditions, we have already discussed about the customs and traditions. Customs and traditions, again I am repeating the same concept, that Hindus are governed by Hindu law, Muslims are governed by Muslim law. Monogamy is allowed in Hindu law, polygamy is allowed in monogamy is allowed in Hindu law, polygamy is allowed in Muslim law. Polyandry is opposed, is illegal both in Hindu law as well as in Muslim law. Then comes the Indian Contract Act 1872. Right. The law relating to contract entered in India. So Indian Contract Act deals with all the laws which are relating to the contracts which are entered in India. The key act which regulates the Indian Contract Act, it is a key act which regulates the Indian contract law. Right. The Indian Contract Act extends to the whole of India except the state of Jammu and Kashmir. This is what we used to learn before 19th August, before 5th August 2019, because 5th August 2019 was the date when the special status of Jammu and Kashmir was removed from the Constitution of India. The revocation of Article 370 has taken place on 5th August 2019. So after the revocation of Article 370 from the Constitution of India, the Indian Contract Act and other laws which were earlier not followed by the state of Jammu and Kashmir are now being followed. So the Indian Contract Act 1872 extends to the whole of India, including the union territories of Jammu and Kashmir and Leh. Right. Development of Indian Contract Act 1872. Dear viewers, originally this Contract Act has 266 sections. Law of Contract starts from section 1 to section 75. The Sale of Goods Act will be there in from section 76 to 123. Special contracts will be studying about indemnity, guarantee, bailment, pledge, agency, etc. from section 124 to 238. I'll be explaining each and every word when the concept comes. Right. Contracts relating to partnership will be learning under section 239 to 266. Then comes meaning of contract. Right. The word contract has been derived from Latin word contractum, which means drawn together. Drawn together. If you want to perform the contract, there must be two parties. One person cannot contract with himself. I cannot call myself as Tulja Bhavani. There must be somebody to call me as Tulja Bhavani. If I am sitting alone, I cannot say, come on Tulja Bhavani, drink water, come on Tulja Bhavani, read, sleep, etc., etc. There must be somebody who has to name me by the name which is kept by my parents or my nickname, like that. So in order to enter into contract, there must be two parties, right? A contract is an agreement between two parties which can be enforced in the court of law. Here, two words, we can see that there are two important words. One is agreement, other one is enforcement, and another one is two parties. So as I said, in order to make contract, we require two parties. Contract consists of agreement and enforceability. Now what is agreement, what is enforceability, we are going to learn in our next slide, this one. We enter few contracts. I'll be telling you what is agreement and what is enforceability. But before that, let us look into this slide. We enter few contracts without our knowledge. Viewers, have you ever thought that we have entered so many contracts without our knowledge? We enter into contracts from the morning till we go to bed in the night. For example, in the morning we take milk. So when we are purchasing the milk, we are entering into contract with the milk vendor. We purchase the newspaper, we are entering into contract with the person who supplies the newspaper. Then we enter into contract with the shopkeeper in purchasing our groceries, etc. You can see an image on the right hand side where a child is being entertained by his parents through a smartphone, through some toys, through a laptop, through books, etc. So all these things are purchased from the market. So when these things are purchased from the market, we are entering into contract with the manufacturer or from the shopkeeper who is producing them or who is providing us those commodities. Right. The next slide. Definition of contract. Right. I have to explain you what is agreement and what is enforceability in order to make contract. It is visible here now. So definition of contract. The definition of contract is given in section 2, clause H of the Indian Contract Act 1872 as an agreement enforceable by law is a contract. Again, a contract needs two things. One is agreement, other one is enforceability. So contract consists of agreement plus enforceability. What is agreement? What is enforceability? Now the question arises, what is an agreement and what is an enforceability? Right. So definition of agreement. The definition of agreement is given in Indian Contract Act 1872 under section 2 clause E as an agreement is defined as what they are saying, every promise or set of promises forming consideration for each other. Consideration means something in return. So what it is, something in return, something, if I am giving you my telephone, you have to give me money. If I am giving you one biscuit, you have to give me one chocolate. That is the policy of the kids. So what the kids, if I am eating something, you have to give me something, sharing. So here consideration means something in return. So the definition given by section 2 clause E is every promise or set of promises forming consideration for each other. Now the question arises, what is a promise? The word promise is again defined by Indian Contract Act under section 2 clause B as when a person to whom the proposal is made. Proposal means offer. When a person to whom the proposal is made signifies his assent. Assent means what? Approval thereto. The proposal is said to be accepted. A proposal, when accepted, becomes a promise. I'll take the help of a small example. When a person to whom the proposal is made, what I am doing now at this time, I feel like having a cup of tea or coffee. So what I have done, I have proposed my friend. Proposed means what? Making an offer. I made an offer to my friend. Hello, Mr. Ram, will you come for a cup of tea with me? I made a proposal. Now the opposite person, what he has done, he has given his approval. He signified, he has given his assent to me. Assent to me means what? Approval. I said, hello, hello, Mr. Ram, would you like to come for a cup of coffee with me? He agreed. He has given his approval. So when he has given his approval to me, the proposal is said to be accepted. Whatever proposal I have made to him, when he has given his assent, that proposal has been accepted. When he has accepted, that accepted proposal has become a promise. I asked him, hello, Mr. Ram, will you come for a cup of tea with me? When he has given his approval, when he has accepted, that means he had made a promise. Yes, definitely I am going to come with you for a cup of coffee. So therefore, an agreement is an accepted proposal. What is an agreement? An agreement is an accepted proposal. He has accepted that proposal, and that proposal has become a promise. Right. Now, in an equation form, it can be written as, what agreement can be written as? See, to make an agreement, there must be two parties. I made an agreement with Mr. Ram. Will you come with me for a cup of coffee? So there must be two people. So to make an agreement, there must be two people. One person has to make an offer. I made an offer to Mr. Ram. One person has to make an offer and another person has to accept that offer. Offer proposal by one party and acceptance by other party. So in equation form, you can write agreement as offer plus acceptance. I made an offer. He has given his acceptance. This has become an agreement. An agreement is a accepted proposal. Right. Now, enforceability. To make a contract, there must be two things. One is the agreement, another one is the enforceability. Enforceability means legal obligation. Legal obligation means what? Perform their obligation. Failure means whenever we are entering into a contract, there must be a legal obligation. Legal obligation means if either of the party fails to perform their contractual obligation, the other party, the aggrieved party, has a right to seek the justice. They can go to the court and they can claim the damages. In case of cup of tea, cup of coffee, there is no enforceability. Why there is no enforceability means I'll explain you in our next slides. Right, because Ram is my friend, and for a cup of coffee, if he is not coming, I cannot go to the court and I cannot say the judge that, sir, he is not coming for a cup of coffee in spite of being my best friend. So there are certain contracts where enforceability is possible and there are certain contracts where enforceability is not possible. So what are those agreements? Where enforceability is possible, and what are those agreements where enforceability is not possible, we'll be studying. Right. Now, consensus addendum, identity of mind. Dear viewers, whenever we are entering into a contract, whenever we are entering into an agreement, the terms of the agreement should be identical. Means whatever term is there in my mind, the same terms should be there in the minds of the other party. To make the students clear about the word consensus addendum, intentionally I have taken the example of Aladdin, because in our classroom majority of the books and majority of the teachers say about consensus addendum like identity of mind, what I have written, and they give the example of cars. Mr. A wants to sell his red car. Mr. A has two cars. One is red car, another one is blue car. So Mr. A wants to sell his red car to Mr. B, and Mr. B is in the intention that A wants to sell his blue color car. Here both the parties are not having identity, similar identity of mind. A is thinking of giving his red car. B is thinking of purchasing the blue car of A. So here in our screen, you can see that Aladdin and Abu both are thinking. Both are thinking of the same idea. Both of them were in certain problem. So Aladdin is thinking that with whom he has to take the help of. And in the mind of Aladdin, only one person's thought is coming, and he is none other than the genie. And here, if you see the Abu, even Abu is also thinking in a similar way that only one person can help us, and he is genie, and Aladdin is also thinking of genie. So here both these parties have consensus addendum. They are thinking in the same direction. So when the parties are making agreement, the terms of the agreement should be understood by the parties in the same manner. This is called as consensus addendum, which means identity of mind. Right. Agreement presumed to lack enforceability. Just now I said that there are few agreements which do not have enforceability, and there are few agreements which have enforceability, like the social agreement, domestic agreement, moral agreement, religious agreement. These are the four agreements where enforceability is not possible. We'll be learning about all these things. Right. The social agreement. Social agreement means what? These are the agreements which are entered between the friends. Right. Domestic agreements are those agreements which are entered in between the family members. Then moral agreement, these are the agreements which are entered both between the friends as well as the family members. Right. Then comes the religious agreement. These are the agreements which are entered by an individual with some spiritual trust, or an individual to his God. Now see, social agreement. Here you can see very clearly in the slide, I have written holy on the left side. In the middle of my slide, there are certain kids playing the color, and on the right hand side you can see the image of novel coronavirus, and on the downside you can see a person who is suffering from a running nose problem, and he is coming from somewhere else. On his entry, one person is running away through a mask. So I'll take the help of a small story here. The kids are playing Holi, and one person, he is throwing color from his building on his friend. So this friend, he stays in foreign country. So what he has done, foreign country, that to be he is staying in China. So let us take the example of these two friends, Mr. A and Mr. B. Mr. A is throwing color on Mr. B. Mr. B is staying in China. So both of them are childhood friends. A has made a phone call to B, saying that Holi is a festival of love and Holi is a festival of colors. Why don't you come from China all the way to India for celebration? So they made a proposal 6 months back. So what Mr. B has done, he booked his flight ticket, and all the way from China, he traveled to India, and he reached before May 9th, March 9th was the Holi, I think. So he reached from China to India. When he is having a running nose problem, on seeing him, Mr. A is running away, because coronavirus is the China is the birthplace of coronavirus, and when Mr. A is coming from China, Mr. B is coming from China, A assumes that he is suffering from coronavirus. Merely suffering from fever, we cannot say that a person is having coronavirus or not. Coronavirus has its own symptoms. So Mr. B is not even tested positive for coronavirus. He is simply suffering from a fever and a running nose. So by seeing this, Mr. A is running away. So what I want to say is, there was an agreement made between these two friends before coming to India. So all the way, traveling all the way and spending such a huge amount, when he came to meet his friend is not even asking him about his howabouts. He is simply running away. Now Mr. B cannot sue A, saying that I have spent such a long time, I have spent such a huge amount and I came from such a long distance to meet you. Now you have to give me my charges. He cannot ask because there was no intention between these two parties when they entered into an agreement of participating in the festival of Holi. So this agreement cannot be enforced. It cannot be taken to the court of law. Right, then comes the domestic agreement. Domestic agreement, as I said, it is an agreement which is made between the family members. On the left hand side, you can see a child sitting on the shoulders of a superman. And for every child, every son, his father is a superman, his father is a hero. So what this child has done, he asked his father to purchase a bicycle for him. So his father said that I'll purchase a bicycle for you only if you pass in your exam. So what the child has done, he has made all day and night one and he continuously studied. You can see the slide on the left hand side. He is continuously studying, and like this he has topped the class. When he has topped the class, he asked his father for the bicycle. His father failed to provide him the bicycle. Now the child cannot file a case on his father because it is a domestic agreement. When the agreement was made, there was no intention between the parties that if the other party fails to perform their obligation, the suffered party, the aggrieved party, will go to the court and file the case. So domestic agreements also cannot be enforced in the court of law. Right, now domestic agreement. Here I have written Balfour versus Balfour in the year 1990. Dear viewers, it is one of the most important case law which is being asked in the exam. Balfour versus Balfour. Balfour versus Balfour. Right. It is a domestic agreement which is entered between wife and husband. Here what happened means Mr. Balfour was a government officer working in London. He has got transferred to Ceylon and was asked to report immediately. When Mr. Balfour was reporting to his Ceylon, he was very much interested to take his wife along with him. So his wife suddenly she was not feeling well. So what he has done, he asked his wife to stay at home and he promised his wife that every month he'll be sending her $30 for her expenditure, for her pocket money, which is called as the pin money. So a pin money will be sent. Pin money is the money which is given for a housewife for her household expenses or her personal use. So Mr. Balfour has promised his wife to pay 30 pounds every month. So when Mr. Balfour has gone to Ceylon, till few months he has given amount to his wife. Later, due to some situations, some circumstances which were not known to Mrs. Balfour, he stopped paying the amount. So Mrs. Balfour, she waited for few months, and when she did not get the amount, she simply filed a suit on Mr. Balfour. The judge has denied the case, saying that it is a domestic agreement between wife and husband which cannot be enforced, because when the agreement was made between Mr. and Mrs. Balfour, there was no internal quarrel between them. They were living very happily. He even wanted to take his wife along with him to the Ceylon, but she was not feeling well. So there was no intention among the parties of suing each other in case if the other party fails to perform their contractual obligation. Then comes the religious agreement. Dear viewers, you can see that there is one temple on the right hand side and God sitting in the temple. So, let us take the example of a person called Mr. Dhruvansh. What Mr. Dhruvansh has done, he has come to the temple in order to take the benefits of the Almighty Bhagwan, and after offering prayers, he made a promise to the priest that I am going to paint the temple in the next festival. So, what has happened? The festival has approached, and Mr. Dhruvansh has failed to paint the temple. Now, the priest cannot go to the court and cannot sue Mr. Dhruvansh because it was a religious agreement. When the agreement was made, there was no intention in the minds of the party that if either of the party fails to perform their contractual obligation, the other party is going to sue them. But remember one thing here, the court has denied the case. Even if the priest goes to the court, first of all the priest will not go, but if in case the priest files a case on the person, that is Dhruvansh, for recovery of amount or for the promise, the judge will ask him, okay, he made a promise to you that he will paint the wall. Have you painted the wall? If on the promise made by Mr. Dhruvansh, if the priest has painted the wall, the priest has incurred some expenditure. So if the expenditure is incurred, then the court will order Mr. Dhruvansh to pay the amount. If the priest has not painted the wall, if the priest has not incurred any liability, then the court will not ask Mr. Dhruvansh to pay the amount. This was all about the religious agreements. Then comes the commercial agreement. Commercial agreement, I told you that commercial agreements are those agreements which are related with money. Whenever the word money comes, remember that it is enforceable. Na baap bada na bhaiya, sabse bada rupaiya. So whenever money comes, enforceability come. Here there are two friends. Let us take Mokshit and Harshit. So Harshit is holding a mobile and he's showing his mobile to his friend Mokshit, and he's promising him and he's telling him, will you purchase my mobile for 5,000 rupees? Mokshit accepted. Now Mokshit is taking the money and giving to Harshit. Harshit said he is not interested to sell the mobile. Here the offer and acceptance both were happened, and in case of entering this contract, there is a presumption that if either of the party fails to perform their contractual obligation, the aggrieved party can file a case. Here the sentiments of Mr. Mokshit are hurt, right? He imagined so many things that if I get the mobile, I can take my selfies because the camera is very super in this mobile. So here Mr. Mokshit can file a case against Mr. Harshit and can recover the damages, or or he can even make Harshit to sell the mobile, right? Then comes distinction between an agreement and contract. What is the difference between an agreement and contract? Dear viewers, here there are three columns. One is basis of distinction, second one is agreement, third one is contract. Basis of distinction, first one is definition. So the definition of agreement is given in section 2 clause E. We have already learned about the definition. It was every promise or set of promises forming consideration for each other is an agreement. Then contract, section 2H, an agreement enforceable by law. If any agreement is not enforceable by law, it is not a contract. And one thing to remember, that all agreements are not contracts, but all contracts are agreement. ये line आप लोगों को याद रखनी है. You are supposed to remember this line because in exam he may ask, all agreements are not contracts, but all contracts are agreement. Or he may ask, all contracts are agreement, but all agreements are not contract. How we have to remember this is, see, all MCOM students are BCom students and all BCom students are not MCOM students. This is the easy way to remember. If I have done my MCOM, it implies that I have done my BCom. If there is a contract, it means there was an agreement. If there is an agreement, there is no guarantee that there will be a contract. If I have done my BCom I am comparing with agreement, and MCOM I am comparing with the contract. If I have done my contract, if I have done my MCOM, it means I have done my BCom. If I have done my BCom, it does not mean that I have done my MCOM. If I don't like to do MCOM, I will do my MBA. If I don't like to do MBA, I will do my MA, but 100% I am not going to do my MCOM. So all agreements are not contract, but all contracts are agreement. All MCOM students are BCom and all BCom students are not MCOM. I really wondered on seeing the nameplates of certain lawyers. What they write is their qualification as LLB, LLM. There is no need of writing LLB and LLM. Boss, if you have done your LLM, it means that you have done your LLB. I don't know why they write. Right, now here, the constitute. The second point of distinction is the constitute. So agreement consists of offer and acceptance. I told you what is an offer, what is an acceptance. We have one chapter for this offer. What is offer, what is acceptance, what is consideration. So when that comes, I will tell you in simple terms. I told you what is an offer, then what is an acceptance. Right, then in contract there are two terms again, agreement and enforceability. I told you that there must be an agreement and there must be an enforceability. If there is no enforceability, then there is no contract. If there is no enforceability, then there is no contract. So enforceability is the lifeline of the contract. It is just like a soul in the physical body. If there is no soul, then the body is waste. If there is no enforceability, then contract is waste. Then the third distinction is one in another. It means every agreement need not be a contract. I said that every BCom student need not do his MCom. Then all contract need to be an agreement. They are the results of the agreement. All MCom students should be the BCom students and all MCom students are the results of the BCom students. It means if you are doing your MCom, it means you have done your MCom. It means you have done your BCom. If you are doing your MCom, it means you have done your BCom. Then comes consideration. In case of agreement, consideration is not required. In case of agreement, consideration is not required. I am giving you this. I am donating so and so amount to the temple trust. I don't expect anything from the temple trust. I am gifting something to my child. I don't expect anything from my child. There is no expectation. There is no consideration. If I am gifting something to my friend, I don't expect something from my friend. Now another is here in case of contract. Consideration is compulsory. I have to give you money in order to take something benefit from you. If I'm taking some help from you, I have to pay something to you. If I'm selling you my mobile, you are taking my electronic gadget. In turn, you are giving me some money. So both the parties have to receive the consideration either in cash or in kind. Then comes legal obligation and enforceability. So in case of agreement, it is not enforceable. I said that agreements are not enforceable in the court of law because there was no intention among the parties to enforce the other party in case of failure of their contractual obligation. My father has not provided me the bicycle. When he did not provide me the bicycle, I am not going to drag my father into the court. Right. Here, in case of contract, enforceability should exist. Enforceability, as I said, it is the lifeline of the contract. Then comes formality. Formality. Agreements are informal in nature. I simply made a proposal to Mr. Ram. Hello, Mr. Ram, are you going to come with me for a cup of coffee? I'm informally inviting him because he is my friend. I have that much liberty on him. Then in case of contract, it is a formal in nature. If I'm making some proposal to somebody, if I'm making some proposal, hello, Mr. X, are you interested in buying my car? If Mr. B is interested, he will give his proposal. Both of us will write some terms and conditions. He will sign, I will sign. So like this, the contract will come into existence. Now, this was our last slide. So thank you so much for watching me and listening me with patience. And if you like my video, please share my link. The main intention of my teaching is spreading of knowledge. Dear viewers, whatever I am teaching you, I have drafted a book and very soon it is going to come into the market. So thank you for giving me this opportunity. So here, let us have a recap. If you want, let us have a recap of our today's class. I think recap is not required. Right. So I'll make a move now. Have a nice day. Jai Hind, Jai Bharat.